Welcome to Florida is Our Domain.
Welcome back to Florida is Our Domain with Anthony Policastro. Tony is a Florida eminent domain attorney and the founder of Policastro Law Group, with over 30 years of experience representing national corporations, business owners, and individual landowners across the state. Tony, he's joined today by Jared Silver, an eminent domain attorney at the firm, who previously handled these cases for the Florida Department of Transportation. I'm Lisa Mosbey, your host, and in this episode, we're talking about eminent domain jury trials, from jury selection and expert testimony to trial strategy and presenting property impacts in court. Welcome, Tony, Jared. It's a pleasure to be with you today.
Thank you, Lisa.
Great to be with you, Lisa.
Thank you. You both have extensive jury trial experience. What are some of the important considerations in selecting jurors?
I think for when you're representing a property owner, I think it's always great if you can get folks on the jury that have ownership of a home or a business or something that they understand the stake, let's put it that way, that your client is going through by the taking of his business or her home. And I think that those are important qualifications, distinctions to look for in jurors that you want to select. Jared?
I agree. I also, you definitely want to have someone who has skin in the game themselves. I also look for people who have close family members that are also in that position of ownership as well. For a business, you might want to look for someone who's been a general manager of a business who may not have ownership, but certainly knows what a business goes through on a day-to-day basis. So you want to have people who can put themselves in the shoes of your client as much as possible.
And Jared, we'll start with you on this one. How do you prepare your expert witnesses for a jury trial?
Well, you want to have them review everything that they've done, their own work product, at least more than once, at least. You also want to have them review what the other side has done. If you're going to be going to a trial, they presumably will have been deposed already and been questioned about all their findings. So you want to have them review the transcripts of that, because you don't want to be in a situation where they're saying something at trial that contradicts what they said earlier in the deposition, and then they've created a credibility issue for themselves in the eyes of the jury. So you want to have them prepare more than once, if at all possible.
And Tony, have you ever put your property owner or your client on the witness stand? And do you believe this is important?
I think it is. I have. And I think it is very important to put the client on. The client can really articulate better than anybody about how the taking affects his or her property, his or her business. I think that they can tell the story of how this taking is really impacting them and their lives and their families. So I do think it is particularly important to hear from the property owner or the business owner. Let the jurors hear the perspective of that owner. And I think that hopefully, if your client is relatable, and you've also made sure, you've talked to the client before, made sure that the client is prepared, especially for any cross-examination questions they might encounter. I found that the property owner or the business owner does pretty well speaking for themselves. And I do think the jurors want to hear from that individual.
Before we put that client or that property owner on the stand, what is important to convey to the jury in your opening statement?
I think an opening statement is really the roadmap to what the jurors are going to see during the course of the trial. So you definitely want to let the jurors know who you're going to be hearing from, what witnesses. So if you've got, an appraiser, an engineer, an accountant, whoever you're going to put up there, I think you want to let the jurors know who they're going to hear from, what generally the testimony is going to be. I think it's a good opportunity to give the jurors an overview of the property and the take, and you can demonstrate that by using some exhibits. So I think, getting them familiar with the property that's at issue is very important. I also think it is extremely important to not overpromise. So you want to basically make sure that the jurors understand what it is that you're going to have folks testify to. but you're not going to say something that you cannot prove through your testimony or evidence during the course of the trial.
That's great. And also, I think it's important to emphasize that our clients are not the ones who wanted to be in this process, that the government forced them to be here as property owners and as business owners. And that's the reason why we're all here. And they're just here to seek their full and just compensation as the Constitution allows. So it's important for the jurors to know that the reason everyone's here is because of the government's action and not because of our clients.
That's for sure, Jared. Thank you for that. But what types of trial exhibits do you use in a jury trial? And what do you believe is the most effective in these situations?
Well, we use, you're going to use engineering plans, you're going to use construction plans, you're going to use sketches that are created by your experts, by your engineers, and by your land planners. You want to blow them up into a proportion where the jury can see them on poster boards. We're not really a fan of slideshows or PowerPoints because those, you're not holding that image in front of the juror. You're just putting it up there for a brief period of time and then moving it along. But if you put these sketches onto big poster boards, you can keep it in front of the jury and keep their attention. And also, you can also have the jurors take it back with them as a visual aid into the jury room when they're deliberating. So those sketches, from the engineers, how the property is going to be affected, how it was before the property was taken, how it will function after it's taken, and any idea to cure that deficiency. I think it's important for the jurors to have it, and we make sure that they do.
Yeah, I think that I like exhibits because I always use a lot of exhibits in my closing. And so you're using both demonstrative exhibits that aren't necessarily in evidence, but then you're also using a lot of exhibits that are in evidence. So I think that's really important to go back through that testimony, being able to hold up those exhibits. Difficult to do with the PowerPoint. I mean, it can be printed out and, handed to the jury. But I do agree with Jared that I think that the larger exhibits, you've got a 12-person jury, which is very unique in eminent domain in Florida. The only time you get a 12-person jury, we've talked about this before, but is when the death penalty arises or it's an eminent domain taking. Everyone else gets just 6 jurors. So when you've got 12 jurors in the box, and you always have a couple alternates as well. That's a lot of people. So it's good if you have large exhibits so everybody can see what's going on. And obviously some people, their eyesight's better than others. So I do think those larger exhibits are very helpful. I know they're helpful to me. I like hands-on to hold the exhibits when I'm doing a closing statement for sure.
And as a layperson, I've sat on a jury recently, and having those things large so you can see and not moving quickly is less intimidating. We really get a chance to see and hear what it is that you're talking about. I want to talk about cross-examination. How do you each go about cross-examining the condemning authority's expert witness? Tony, let's start with you.
All right. I like to use the depositions. So often, experts are very well trained, and you're dealing basically with all experts, paid for experts, that although they're supposed to be independent, they're really advocating essentially for their client. So with the government witnesses, it is good to take their deposition. Of course, you may not find a lot of flaws, but you can find some, and that they'll misspeak. And you can use that to basically impeach their credibility, get them to admit some things that perhaps they don't want to admit. And I think that is the best way to approach it. You're not going to want to ever, and you've probably heard this before, is ask a question you already don't know the answer to. So you don't want to just blindly ask an expert witness, something that you don't know what they're going to say. So I think it's important to use those depositions to box them back in to what they previously said. Even if they want to correct the record in front of the jury, it's still in front of the jury. And I often like to be able to ask the judge to approach them, hand them their transcript, and have them actually read it to the jury, the transcript from their deposition.
Yeah, I agree with Tony with everything he said. Also, this is sort of the inverse of the question you asked earlier about how do you prepare your own experts for their testimony. This is preparation for the opposing side. If they have not done the preparation correctly and they've not gone over their depositions, they may be answering a question differently than they did in a deposition, and that brings their credibility at stake, as Tony said. I also think it's important, especially since we're dealing with real estate. Every appraisal for appraisal experts is going to have comparable sales for the businesses or the land or the house that they're dealing with, and those comparisons are not going to be perfect. They can't be. So it's important to try to emphasize in that cross examination the differences between the comparables they've selected and your client's property. So you can so even if they're not willing to say, oh, this is so much different than the other one. Okay, but is this part different? This house 2,000 square feet, but your comparable is only 1,500 square feet? Is there 3-to-1 land ratio on your comparable house versus 4-to-1 for our clients? And so it's small things like that, but they add up, and you can paint a picture for the jury that this appraiser with their comparables really shortchanged your client.
Tony, I'm curious, how long does a typical condemnation jury trial last?
Usually we ask for 5 days. So it's usually about that. Sometimes it can go longer if business damages are at stake. If it's a property owner and a business being affected, they own both, then sometimes that could be longer than a week. That could go 7 days or so. Sometimes it's shorter. Sometimes if it's a taking of vacant land, the trial can go 3 to 4 days. However, you have to remember all the components that go into an eminent domain case. So like all cases, you have to pick the jury, right, which is voir dire. And that can take a half a day. Sometimes it's taken me an entire day to do that. Then you have to do opening statements. The government usually goes first, putting on all their witnesses. Then you respond on behalf of the property owner or business owner. The government can then put on rebuttal testimony as well. Now, in between all of that, you have the right to do have the jurors go out and actually go to the property and do a site inspection. And the judge in the court arranges that with a bus to take all the jurors out to the property, and they get to basically walk around the property and see how that taking affects the property. It's staked before they get out there, so the jurors will know through the survey and the staking where the taking is going to be, because most of these cases happen, they're tried before the actual road construction occurs. And so the road isn't in yet. So the jurors have to go out there, take a look at all of that. And that definitely can take a good half a day to get them out there and back. And so with all of that and closing statements as well, it can, easily take a week.
Sure.
Yeah. And if
Sounds like it.
the shortest one that I've ever either been a part of or heard of was 3 days, and that was for vacant land, which had only one variable at stake, and that was the cost of the actual land itself. Whereas, as Tony said, you're bringing in if there's structures involved, if there's a business involved, if there's damages to the property, all these other factors that and variables that can be added in add time. So it's a good rule of thumb. Prepare for a week, maybe even more if you have accounting issues with business damages, but it's no less than 3 full days, even in the simplest of circumstances.
And you had mentioned closing statements, so that would be the final aspect of the jury trial. How do you each craft your effective closing statement to the jury? Jared, let's start with you.
Yeah, I think it's a culmination of what we've talked about for this entire session. You're using your exhibits that you put on the large poster boards that point out the qualities of your client's property as opposed to the comparable properties that the government's appraiser has used. You're pointing out the inconsistencies that the opposing witnesses have that you've shown in their depositions with their appraisal and with their engineering report. You're bringing that all together. You painted the picture throughout, starting with the opening statement and telling what the case will entail, although not overpromising, of course. And now that testimony has come out and it's borne fruit to what the roadmap you've laid out in the opening statement. And now you're bringing that all together with those exhibits, with the testimony, with the inconsistencies you pointed out in the other side. And you're saying this is why our client should have their full and just compensation, be it our number and not the government's, which has shortchanged our client.
I would add that what I like to do too is also work with the jury instructions, because there's going to be instructions the jury is given by the judge at the close of the testimony and the end of the closing arguments. And so I like to go out and let the jurors know what they are going to be instructed by the judge and how that interplays with the testimony, for fair market value, for highest and best use. So you want to go over those jury instructions and make sure that the jurors understand how it relates to the case. I also like to go back and refer to the fact of what I discussed or brought up in opening statement and how that has been proved and delivered upon by myself through the testimony of the expert witnesses and the evidence that they've seen. It's also a good time to also bring up the flaws, certainly of the other side's case. I often like to make things very simple. I mean, I've used, analogies such as, Sesame Street, going through the comparable sales, which ones don't belong, for the government's sales. So, and pointing those out. So you do want to try to keep a little bit of humor, but I do like to be pretty direct, and I like to be pretty revved up for closing, because that's really the time where you can rip apart the other side's case, hopefully, that you've gotten out everything that you need to go after the other side in closing, but also reinforce the testimony of what they heard from your experts. Sometimes you can get a transcript of either side during the time of the trial testimony, and then you can read that back out to the jurors and say, Mr. So-and-so said this, during the course of his testimony, and we've, disproven that. Or you can go ahead and, reinforce what your experts said by having their testimony, read back out to the jurors to show that you've proved it during the course of the trial.
Sure. Tony, Jared, thank you so much for walking us through the steps of eminent domain jury trials. I appreciate it.
All right,
Thank you,
Lisa.
Pleasure being with you today.
Folks, thank you for listening to today's episode of Florida is Our Domain. Jury trials can play a major role in determining how property impacts are ultimately evaluated and compensated. Your property or business is being affected by a public project. Visit Policastrolaw.com to schedule a consultation and learn how Tony and his team can help. Don't forget to like, leave a review, and subscribe to the show. Come on back next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.